You can place the file.
I can bring it.
First, you take the judgment. This judgment. Where's this accused? Stumps from? Is on bail? That from the evidence discussed above, this court finds that PW2, the brother of the deceased, has categorically stated in his evidence that his deceased sister, on the day of the incident, she was trying to light a heat using kerosene oil. The husband poured kerosene over the head of the deceased and lighted match on her. The deceased was burned from head to toe. PW1 shouted for help and from the neighbors shouted for help from the neighbors. In cross-examination, PW2 confirmed by way of direct oral evidence that he saw the accused poured kerosene oil on the body of the deceased. PW2 has made one stray statement that he did not see that the accused lighting a fire stick on the body of the deceased. It is nobody's case that the deceased was burned with a fire stick. As such, the contention of the defense that PW2 did not witness the accused lighting the fire does not hold any water. When the eyewitness stated that he saw the accused pouring kerosene oil and lighting a match over the body of the deceased, direct oral evidence cannot be brushed aside in absence of any plausible contradiction. The evidence of the eyewitness corroborates with the testimony of PW2, PW3, PW4, before whom the deceased made oral dying declaration. The evidence of PW1 finds corroboration with the post-mortem report, Exhibit 1. PW2 has stated that the deceased poured kerosene and the victim was burned from head till toe. This evidence is consistent with the post-mortem report, which reveals 100% burn mark. Scalp was charred, chest and abdomen was charred. The evidence of PW2 clearly reveals that the accused had poured kerosene oil over his wife and thereafter he lighted the fire, which clearly shows that the accused had the knowledge that the fire was sufficient to cause death of his wife. The accused had burned his wife by pouring kerosene oil, which was sufficient in ordinary course to cause death of a person. The act of the accused of causing death is culpable homicide amounting to murder. None of the exception of section 300 of IPC is attracted. The argument of the defense that the information was the argument of the defense that the information was not the informant was not examined. The informant was not examined in the instant case and the FIR has not been established does not dislodge the prosecution case. It is a settled law that non-examination of the informant is not fatal for the prosecution case if there are other sufficient evidence. In Krishna Mochi versus State of Bihar, the Honorable Supreme Court dispelled the argument that non-examination of the informant would entail acquittal of the accused if there are other prosecution evidence and held. We just reproduce the paragraph. The contention of the defense that the filing of the FIR has not been established runs contrary to the evidence on record. The witness PW6, the officer in charge of the Joy police station, stated in his evidence that he received the FIR dated 8/9/2006, filed by Barwell Singh Sari, headman of Mokla village, which was registered as Joy PS case number 104 under section 302. The IOPW8 stated in his evidence that the informant disclosed that the family members of the deceased informed him that the deceased with the burn injuries had given a declaration before dying that she was burned by her husband. The filing of FIR has been established by the registering authority and the FIR has been exhibited as exhibit. Has been exhibited as Exhibit 2. In Babli versus State of Chhattisgarh, the Honorable Supreme Court held Once the registration of the FIR is proved by the police and the same is accepted on record by the court and the prosecution establishes it beyond reasonable doubt by other evidence, cogent and relevant evidence, it will be impossible for the court to ignore the evidentiary value of the FIR. The FIR Exhibit 1 has been duly proved by the statement of PW10 Sub-Inspector Suresh Bhagwat. According to him, he had registered the FIR upon statement of PW1 and it was duly signed by him. The FIR was registered and duly formed a part of the record of the police station, which were maintained in normal course of its business and investigation. Thus, in any case, it is a settled proposition of law that FIR by itself is not substantive piece of evidence, but it is certainly a relevant circumstances of evidence produced by the investigating agency. Merely because PW1 has turned hostile, it cannot be said that the FIR would lose its relevance and cannot be looked into for any purpose. In case in hand, the FIR has been brought on record as Exhibit 2. Non-examination of the informant would not falsify the other evidence which has been established beyond reasonable doubt by the prosecution. This court finds that the IO during the course of investigation has made a seizure of material exhibit 1, material exhibit 2, 3, 4, while seizure is exhibit 4. The seized material was sent for forensic analysis to connect the material exhibits with the crime. Prosecution has failed to exhibit the forensic report. As such, the seized material loses its significance. This court has not placed reliance on the material exhibit. Nevertheless, the prosecution through the evidence of PW1, PW2, PW3, PW4 has established that the accused has committed culpable homicide amounting to murder. For the reasons discussed above in the foregoing paragraph, on the point which arose for determination, this court finds that the accused stands wrong, guilty of committing an offence of culpable homicide amounting to murder. Accordingly, the accused stands wrong is convicted under Section 302 IPC. You want a hearing of sentence today?
No, I did.
What do you do with the hearing of sentence? For time, what do you want? We are not sentencing him to death.
There are two options on it.
We are not sentencing him to death.
Give me time, some time.
For what?
Friday.
When we are saying that we are, what you do? You'll ask for minimum sentence, isn't it?
Yes.
So we are imposing minimum sentence, life imprisonment. Okay. We take hearing sentence. What is that? You want life death sentence? Huh? We are praying for death sentence, then we'll hear it. Is the prosecution praying for death sentence? If you can convince me that this is a case where we can sentence him to death, then you satisfy me.
This is not rarer of the rare case, therefore.
All right. Then what is that? What for you will argue? You will argue for minimum sentence, isn't it?
Yes.
Then we are not convinced that this is, if the prosecution is themselves, they are praying for, not praying for that sentence. Sentence him today only.
Second half.
Huh?
Second half.
Okay. Where is this accused?
Yes, time.
Separate him. Please explain him that he's been found guilty.
Stop. Ni dah right control we put me. Mah, the chem yo bakla mi sa wa pengat dengan kurimi. Just ni dah chem we put the right kan eh. The right go một hạt độ sa ni. Mah, đằng em có học việc mình gì mình lại cho hay code lên. Mah, đằng em tự code đằng gì mình lại sa kamat mah. Then ni code ni apa district the right control mi. Mah.
What do you say? What do you want to say?
Em mi của anh ông. Asking for forgiveness.
Ask forgiveness from God. Not from me. What forgiveness will he? He burned his wife alive. All right. Her learned prosecutor on hearing on sentence. Her learned prosecutor, additional prosecutor S. Chansang. Her learned counsel Sri A.B. Pasab for the convict. The convict Tam Surong has been found guilty for an offence under section 302 IPC and has been convicted by judgment in order dated 4/2/2026. In session case number so and so, so and so, so and so. What is your submission? Are you praying for sentence to death?
No, yeah. There is no material.
The learned prosecutor very fairly submits that this case does not fall in the category of rarest of rare case, which calls for maximum sentence of death, which calls for maximum sentence, maximum sentence of death, and prays that the accused may be sentenced to life imprisonment. The defense submits that since the prosecution is not praying for the maximum sentence, the defense prays that the accused may be sentenced to minimum sentence. Full stop. Next para. This court need not to labor much on the sentence. Inasmuch as the prosecution is praying for minimum sentence. Full stop. Maximum punishment for an offence under section 302 IPC is sentenced to death by hanging, and the minimum sentence is life imprisonment. On perusal of the evidence on record, this court finds the accused has committed a brutal murder of his wife by burning her alive. The wife was aged about 23 years when she was burned alive. Full stop. However, on carefully gleaning through the evidence on record, this court is in agreement with the learned prosecutor that this case does not fall within the rarest of rare case and warrants maximum sentence. The don't write accused. The convict Sri Tam Surong is sentenced to life imprisonment with a fine of rupees 5,000 rupees, and in default of payment of fine, he would further undergo simple imprisonment of 2 months. Issue warrant of 2 months. Full stop. uh, the accused is informed of his right to prefer an appeal, and all those things we give it. Okay. Issue warrant of committal of sentence to be executed by district by the superintendent of district prison and correctional home Joaimo. Case stands disposed of on merit. Copy of this judgment will be supplied free of cost. This call this by document.
Supply.
Yes. That's underline that it should be not information, it should be informant. Then I've just underlined, just correct it. Give the copy of
The
this.
convict will be taken.
Yes, yes. That we have already said in the order, the convict was present in the court. He has anything to say? We have sentenced him to life imprisonment.
Em mi kuat mi ong yi.
Accept, accept.
Untuk ada mentu dah pada mukut me sakit me cerita cijingim. Em mi kuat mi ong yi. Aku mak lekut. Kelam kata.
Sorry.
Asking for forgiveness. He may be.
We have forgiven him. We have forgiven him by not sentencing him to death. Otherwise, we would have sentenced, we have forgiven him by sentencing him to life imprisonment. Otherwise, we would have, had we not forgiven him, we would have sentenced him to death by hanging him. Okay? So we have forgiven him, tell him.
Lekut dah mak kai me wam em rai pandrem ke me wa dam em du ke me pasi na. E ke me dia kata wa chom cerita ha po jail. Ma. Kamat. Mji de. Ma. Dang yi mi dang em hop mi online cerita chai kut ma. Tai kut Shillong na. Ma. Explain. Macam lain.
Take him. See that you keep him properly. Check him properly if he's got anything in his body. Check him properly if he's got anything. One more judgment we have. Helm Dakar.
Helm Dakar.
No, Helm Dakar will not deliver today. Helm Dakar. So now we have this Probita welding.
Profit African and Welding Channel have not yet came, sir. We already contact them, and they said they're still on their way.
After hearing the arguments of the contending counsel, this court finds that in adversarial system, the burden of proof is on the prosecution to establish the charge beyond reasonable doubt. This burden of proof never shifts on the defense. The onus of proof oscillates during trial, but not the burden of proof. Prosecution cannot be absolved from discharging its burden of proof beyond reasonable doubt. In a criminal trial, once the burden of proof is discharged, the defense comes into picture to disprove or to create doubts on the prosecution evidence. In this case, before this court, the prosecution has fairly conceded that it has failed on its erroneous duty to discharge the burden of proof. Nevertheless, this court has scrutinized the evidence on record and finds that the argument advanced by the defense counsel emanates from the evidence on record. There is not even an iota of evidence to connect the accused Probita Tinkan and Welding Suchiang with regard to the charge of murder or concealing the evidence with common intention. The prosecution witness has not even whispered about the involvement of the accused Probita Tinkan and Welding Suchiang. Prosecution has established through the evidence of PW5 and Exhibit 3 that the death of Trixon Rabon was a homicide and the injury was severe and it was the cause of death, which makes the offense culpable homicide amounting to murder. But who had committed the crime remains unresolved by prosecution evidence. Under the above circumstances, the prosecution has miserably failed. Consequently, the accused Probita Tinkan and Welding Suchiang are acquitted of the charge under section 302, 201, 34 IPC and set at liberty unless wanted in some other case. Case stands disposed of. Then with this Helem Dakar. No. This will deliver next week.
This one?
We deliver next week.
Next week?
Next week. That means deliver, we defer till, till next week. This is also murder case.
It's 304.
304, which part? Part 1, part 2. What is the difference between 304 part 1 and part 2?
Part 1 is like a sentencing part, your Honor. Sentencing part.
What is the difference between 304 part 1 and part 2?
Part. Is the sentencing part, your Honor. In part 1 is the imprisonment for life or imprisonment for 10 years.
When does the case falls under part 1 and when does the case fall under part 2?
The intention part, your Honor. The intention part. The intention part.
What is
There-
intention?
There is a intention or there is no intention of committing the offense. With the intention of causing death or causing such bodily injury or with imprisonment with the intention part. Your Honor.
Huh?
The intention part.
What is that intention?
Yes, Your Honor.
What is the distinction between part 1 and part 2?
Your Honor, in the part 1, the maximum sentence is imprisonment for life and the minimum is 10 years. And in part 2, the imprisonment is 10 years or with fine. That is the difference.
So how do we decide whether it is under part 1 or part 2?
Your Honor,
Yes,
in
prescription.
part 2 of the 304 says that
When will a case come under part 2 and when will the case come under part 1? Yes, prosecution. You stood for trial under section 304.
yes,
Part 1 or part 2?
Your Honor, charge has been framed under 304 only. It's not, it has not mentioned.
So
any-
it becomes very important to understand the distinction between part 1 and part 2. What is the distinction between part 1 and part 2? When will the case fall under part 1 and when will the case fall under part 2?
When the offense is committed with intention, then it falls under part 1.
Where does it say so?
It says here, Your Honor, in the definition, in the punishment, says that causing death with the intention of causing death or causing bodily injury as is likely to cause death. This is the difference.
Part 1 says that with the intention and knowledge.
Yes.
If there is intention and knowledge,
If there is intention of causing the death, is
yes, prosecution, please tell us. What is the distinction between part 1 and part 2? When will the case fall under part 1 and when will the case fall under part 2? See,
yes, sir.
in a murder case,
Yes,
first it has to be established that it is a homicide.
yes,
under section 299. Once it is established that is a homicide, what is homicide? Killing of one person by another person. If it is not a homicide, then what happens? If it is not a homicide, then the case will fall under section 304A, negligence.
Negligence.
Once it is established that it is a homicide, then we have to see whether this is a case which amounts to murder or not. Then we have to check whether the act of the accused falls under section 300. Firstly, secondly, thirdly, and fourthly.
Okay.
Now it falls under 300 if it's a culpable homicide, and it falls under section 300 under firstly, secondly, thirdly, and fourthly. Then it is murder amounting to a culpable homicide amounting to murder.
Yes.
After that, again we go to the exception under section 300.
Yes.
Look at this exception.
Yes.
Now, if the case falls under exception, then it is a culpable homicide not amounting to murder.
Yes.
Then it will fall under part 1.
Part 1.
It's a culpable homicide. It is a murder. It qualifies all the definitions under section 300, but it falls under exception.
Exception.
So it is a culpable homicide not amounting to murder under part 1 if it is under the exception of section 300. But if it's a homicide, and it does not fall under the firstly, secondly, thirdly, then it is a culpable homicide not amounting to murder under part 2.
Part 2.
Not on looking at part 1 and part 2.
So, what we differ this?
You want us to pronounce, we'll pronounce it. We are ready.
It's only been fixed on.
Okay. This day. But next week we'll see. Next Wednesday. Every Wednesday we'll deliver judgment. Wednesday is judgment day. Yeah. We are ready with almost all the cases for judgment. Then of course.
No, this is the third consecutive date.
All right. You want us to today deliver, we'll deliver it. Or we'll do it Wednesday. Wednesday. Till Wednesday, next Wednesday. Wednesday. Yes.
This is present.
Yes. Wednesday we'll take.
All right.
Yes, sir. Kid have given them.
Where is that certificate? Accused name is?
Suki can get in the case record. I'm mistaken there mention only Suki.
Suki,
Yes.
but he's been recorded as Suki. The prosecutor has produced the death certificate of the accused.
He's the brother of our SP prison.
Okay. The prosecution has produced the death certificate of the accused, Soki India. The accused died on 15/1/2026. The death has been registered before the competent authority. The death certificate is taken on record and marked as Exhibit D1. This court is satisfied that the accused, Soki India, died on 15/1/2026. The proceeding against the accused, Soki India, stands abated. Case stands closed. Yes.
Dinas Situng Barat Timur.
So the defendant witness is present.
Okay, we'll examine.
Prof. Bihar.
Because one witness.
Pelon Khar, Sihon Khar.
Yes.
Accused are present.
Yes. Yes. What is this case?
This is a case of 307.
Yes. How many witnesses?
5.
Yes. Which year case? This one?
It's 2010.
Only 5 witnesses. Yes. Just be very brief. Tell me what is the case.
Yeah, the case that on the date of the incident, that is on the 22/5/2010, the victim, he went for fishing at Wamantru River. And while he was there, while he was fishing, then two person, the accused person, both the accused person, they came, followed him from behind his back, and hit him on his lower back of his, on his neck. Then after that, at that moment, then they again chased him. They followed him. He ran. He escaped from them. Then again, these two person, they followed the victim. Then on the way, he met PW2. PW2. He saw PW2 saw him running.
No, just
Saw the
second, one
victim
second, one
running.
second, one second. He went for fishing?
Yes, the victim. Then two accused person, they came to the PO and then they followed the victim and hit him on his lower back, on his neck.
With
They
what?
hit him
With what?
with a weapon.
What weapon?
But that weapon was not seized by the IO because the IO, he tried to seize the weapon but could not be found.
Alright.
From the PO. He went to the PO.
Okay. Okay.
And then after that, this victim, then he ran away from the PO, and then PW2, he also went for fishing in that area only. Then he saw him. He saw the victim was running. Then he also saw the injury on his lower back, on his neck. He saw. Then at that moment, then one cultivator passed by. Then the PW2, he asked from those cultivator, who are those person who chased the victim? Then that one of the cultivator told him that the name of the accused person, that Plandakar, both, he told them their name. Then the victim, he ran from that spot. Then he went to his employer, because on the date of the incident, he went with one lady, PW1, who lodged the FIR. She went for washing clothes at Wamatru River, and after he dropped her, then he went for fishing. So after he was hit, and after PW2 saw him, then he went straight forward to the PW1. And on reaching towards PW1, and she saw he was bleeding from the lower back onto his neck, and then she took him home and took him to the hospital for medical treatment. And the victim also saw that one of the accused person is carrying a weapon on his hand with a dart. The victim, while they were chasing the victim, when he turned back, he saw one of the accused person was carrying a weapon in his hand. That is the case, and the case was uh, the case was charged treated under Section 324. And as per the evidence of the IO, also he agreed to the suggestion of the defense that this case does not fall under Section 307. The charge was framed under 307, and during the cross-examination, the IO also had stated that this case does not, Section 307 is not attracted, Section 324 is attracted in this case. And he charge treated the case also under Section 324.
But the charge was 307.
307.
Why?
His Honor, as per the,
Look at the
because
medical.
after the investigation, the IO found that section 324 is attracted and he charged the case under section 324.
So what is your
The
argument?
weapon, yeah, that is my argument, Your
That
Honor.
this should be a case
324.
under 324,
324,
not
yes.
307.
No.
Why?
Because, Your Honor, as per the injury report, the medical report of the victim, PW4, of the doctor, Dr. PW5, in paragraph 5, she stated that the injury found on the body of the victim, it's a cut injury on his lower back, left side, and it appears to be a cut by a sharp weapon. And the nature of the injury is simple injury. That is the evidence of PW5, the doctor.
Yeah.
And the weapon also could not be seized. The IO, he tried to locate the weapon. He went to the PO, but the weapon could not be traced.
Yes. Yes.
This Honor. Your Honor, if we look into the evidence of all the 5 witnesses, none of them have identified the accused. Victim himself also cannot establish among the 2 who had assaulted him.
No, Your Honor, during his evidence, he can
In his
identify
evidence,
both the accused person.
it is clearly stated that he does not know among the 2 who had hit
The
him.
evidence of PW victim.
PW4, Your Honor.
This is
I received someone to appear before the court today. I know of the case as I am the victim. The incident took place on the 22nd, 5th, 2010 at Wamantulu River. While I was fishing, 2 male persons, namely Sihun Dakar and Plan Dakar, came from behind my back and assaulted me on the left side of my back with a spade. I ran from the PO and both the accused person followed me from behind, and I saw Plan Dakar carrying a dao in his hand. Thereafter, 2 persons passing through the PO by the name Moses, another person whose name I do not know, saw me and came to my rescue, and both the accused person fled away from the PO. Later, I was shifted to Civil Hospital Juwai for medical treatment. My statement was recorded by the police. I can identify the accused person present in court today. In the cross, Your Honor, it is a fact that prior to the incident, I do not know both accused person. As soon as I was assaulted, I do not know who committed the offense. But when I turned back, I noticed that it was the accused person, but I do not know who had hit me from among the 2. This is the portion, Your Honor, where the victim have stated.
okay.
I was not hospitalized, but was discharged after receiving treatment. I was hit only once from the left side of my back. I came to learn about the name of the accused person from the persons who came to rescue me. So, Your Honor, in his cross-examination, it clearly stated that he does not know from among the 2 who had
Who hit him?
assaulted him.
Huh. So you mean to say that then he was never hit?
Yes, Your Honor.
If
And
there are 2 persons standing and you are hit, if you don't know who hit you, means you were never hit.
you know, what if the other person was just standing? Either one of them should, at least the prosecutor should establish that, Your Honor.
Who hit?
Who hit him?
If 2 persons are standing, one hit, and who hit him, we don't know. Then we have to let him off.
That question will arise, Your Honor, because this is a case of not a case of death. This is a case where the victim is still alive.
Yeah.
And at that point of time, he should have seen clearly, Your Honor. Because
When somebody is hitting you from behind, how will you see?
It's not a case where a person shoots
When
from
you
a
are
distance.
hit, when you are hit from behind, how will you see?
That can be that have to be answered by the prosecutor. But
No.
as per his evidence, it
We
clearly
cannot ask
shows
the
that
prosecution to answer something which is impossible.
No, Your Honor,
now we cannot
because
convict a person. Suppose there are 2 accused.
Yes.
We cannot say that both of them had hit him because one of them had hit him. We do not know who is that person. Can the prosecutor tell us? They cannot say that.
Is the law so bad that we cannot handle such situation? What were you doing there? Would you admit that you were present there?
Your Honor, in the 313, I have admitted that
Hmm.
it was a sowing season
Hmm.
where I have planted rice paddy. Now, this victim have come to my paddy field for fishing, stepping on my paddy field. Then the entire clan of my family chased him. And while chasing Your Honor, he slipped and fell down and hurt his back. And Your Honor, the medical injury report, it clearly stated there's only half-inch of injury. Half-inch.
Why should we believe you and not believe to the accused?
Half-inch of injury, Your Honor. If I had the intention and knowledge to kill him, Your Honor, it'll be easy because we are in a group, Your Honor. So we have just chased him out.
Suppose-
and then he slipped, Your Honor.
Suppose you take a gun and shoot somebody, and the gun and the bullet does not hit the person, it just brushes the person. You say, no. He had small injury, just small cut with the bullet. So it is not an attempt to murder.
In
It
this
was
case,
small,
Your Honor,
the bullet did not hit.
the intention is not there, Your Honor. The knowledge is not there. And even the act which I've committed also,
How will you know the intentions is a state of mind? How will you know the intention?
you know, you can
He saw you with a
look
dao.
at it.
What do you do? When do you with the dao? You
It's
chase
in the
somebody
paddy
with a
field,
dao.
Your Honor. I have a dao.
Yes.
It's in the paddy field. I
Yes.
carry a dao.
Yes.
Dao can be used for cutting the vegetations and all.
It can be used for some cutting somebody's throat.
That's what, Your Honor. If at all I
If
have
you are
the intention,
if you are chasing somebody with a dao, what does it mean?
Your Honor,
What
if
do you
at
want to
all
do?
I have the intention, I would have used that dao on that day, Your Honor.
You are chasing him.
I
You
have
did
not
not get
used
the see. In an attempt to murder case, attempt to murder has got two parts.
Yes, sir.
The first part is without injury. Even if you give a chase without hurting him with a dao, it's an attempt to murder. Had you caught hold of him, you would have killed him.
Your Honor, that doesn't arise in this case, Your Honor.
So giving a chase with a dao, what does it mean? What do you want to do with that?
The dao, it's not meant to commit crime, Your Honor. The dao,
It may not be.
I'm a farmer, I'm a cultivator.
It may not be. You may have not carried the dao with an intention
The
to kill
dao was
somebody.
carried there to
But-
for my work purpose, Your Honor.
You may not carry the dao for the purpose of committing an offense.
Yes, sir.
But at that moment, that object became a potential weapon.
It can be, but in this situation, it is not, Your Honor.
You give him a chase with the dao. You could have left the dao there. You give a chase
Because the
somebody
dao
with
is
a
in
dao.
my back, Your Honor. It's not the dao was meant, or the purpose of that dao is to hurt someone, Your Honor.
Yes.
And
Yeah.
by the way, Your Honor, the IO himself also have admitted this is not a case of attempt to murder.
IO is not writing the judgment.
Yes, Your Honor.
We are
But
writing the judgment.
he himself who have done the investigation, he have collected the evidence, brought evidence to the
Why
court.
did you not challenge the framing of charge under section 307?
Your Honor, in this case, actually, if you look into the final report, in the front page of the final report, he have described only the section 324 of the IPC. In the back, in the last later portion of the report, Your Honor, he have mentioned 307. So there is a contradiction between in that point.
Did we cross-examine him on that part?
Yes, Your Honor.
What is this?
He agreed, Your Honor, that's not a case of 307. And injury also, Your Honor, it's only half-inch. We don't know, it's written only half-inch, whereas the depth also is not there. It's half-inch, Your Honor, is the injury suffered by the victim. And he was not hospitalized.
Doesn't matter. The PW2, PW1 lady,
Complainant. The
what she says?
She said that on the date of the incident, she went for washing clothes, and the victim, he's a driver, he went to drop her. And after some time, he came running to her with an injury on his back. The blue one.
Okay.
Your Honor, if you look to the cross-examination of PW1, she have exaggerated the fact that the victim was hospitalized. He was admitted in the hospital for 4 or 5 days. Now the victim himself also did not state that he was hospitalized, Your Honor.
Okay.
And the prosecutor can bring to the record that victim was hospitalized for 4 to 5 days.
PW1 is the wife.
PW1 is the complainant.
She's not the wife of the victim.
The victim is her driver in this case. PW1 is the complainant.
With the evidence PW2.
On the day of the incident, I went out fishing at Medru River along with Friday Hing, and while I was about to leave, I washed my hands in the river. And at that time, I saw Meyo Suski crying and shouting for help, and I saw that the victim was assaulted from his backside as there was injury mark on his body. I came to learn about the two persons, namely Plan Dakar and Sishon Dakar, from one cultivator who were chasing the victim. Thereafter, I, along with my friend Friday Hing, took the victim to civil hospital for medical treatment.
Okay, let me study this file. PW3 is, who is PW3? IO.
Yes, IO.
Okay, we'll see this. Are you filing written argument?
If you may allow, I'll file on the next day.
Parties are at liberty to file written argument. So for the hearing. Don't give long date. Yes.
Obliged. It's matter 643 no? I was contacted by the accused this morning that it's not keeping well. We have started in this case.
Started.
However, today it's not keeping well.
Accused. So who is appearing for the prosecution? Additional prosecutor Srimati S. Kindia present. Defense counsel informed the court that the accused is not well. As such, he could not appear before this court today. Refix for examination of the accused under section 313. What is this? What?
Complaint case. R1 killing dog.
Wonder Bank?
I appear on behalf of Neighbor Kosunkon and Register Laming.
Where? What is it?
ISQ Markulat Namaturian.
Yes. Where is the Sri Arbor Key Lindor? Wonder Bank? Bravester Lamen? Niberko Sinkon?
Appear for 2 days only.
Order issue someone. You received someone?
Yes.
And what happened to the someone issued to Bravester Wonder Bank?
Wonder Bank, the someone is not here, so only R1 key.
Where is the order? This is the order. Why is not capturing the order? Who is appearing for the prosecution?
All appears.
Additional prosecutor S. Kindia present. Accused Awarki Lindo. Bravester Lamen. Nibirko Sinkon. Present along with the defense counsel PPD. Accused Wonder Bank is absent without any steps.
For 2 occasions, Your Honor. Brave Buster Lamin and Neighbor Kosunkon.
For Awarki?
Yes. No, Your Honor. Only 2 occasions.
Where is lawyer? Lawyer.
R1 key. When Pridarmi? Pridarmi. That Pridarmi? Then Pridarmi.
Accused Awarki Lindo present.
He hasn't appointed yet, sir.
Huh?
He hasn't appointed a lawyer yet, so
Yeah,
give him time to appoint him. on
Accused
next
Awarki
date.
Lindo present. Accused Bravester Lamen and Niberko Sinkon present along with defense counsel PPD. No report on the summon issued to the accused Wonder Bank. Issue bailable warrant against Wonder Bank. Fix for appearance of the accused Wonder Bank. Tell me to appoint a lawyer on the next day. You got the copy of complaint? Copy of complaint?
No.
Copy of complaint shall be supplied to the accused persons. Yes.
Please step down.
Yes.
Good day.
MSC.
I'm from the complaint or claimant, Your Honor, in this case, Ms. T.
What about the owner and driver?
The counsel who represent OP 1 and 2, he informed me this morning that he's intending to withdraw this as the OP 1 and 2 are not cooperating with him, But however, they are not here, So
What about the
insurance, no.
learned counsel for the claimant? Shri L.S. Khongla present. None appear for the OP insurance. There is sufficient evidence on record to show that notice has been served on OP insurance. That this court, by order dated 11/12/2025, was pleased to grant an opportunity to the OP insurance to appear, in spite of there being evidence to show that notice was served on OP insurance. OP insurance has failed to appear today. It is ordered that the matter shall proceed ex parte against OP insurance. Full stop. Next paragraph. OP owner and driver had entered appearance. However, today they are unrepresented. One more opportunity is given for the counsel for the OP owner and driver to appear. Yes, please bring the witnesses. Bring the judgment. We'll see where the corrections done.